Very good. I see Mr. Coda and Mr. Robinson. Mr. Coda, you are the appellant, so you may proceed.
Yes, Your Honor.
Let me also say, I don't know if you all were on at the beginning. We're welcoming Judge Case, a retired circuit judge from the Sixth Circuit, who is sitting with us today as an associate judge. I think I don't know if I said that at the beginning or not, but if I did and you were not here, now you know who he is, and we welcome him to the panel.
Thank you.
Good morning, Your Honors. I apologize if there's any audio visual issues. My video has cut out a few times during the preliminaries, but I will endeavor to try and keep track of that as we go along. My name is John Coda with Brick Business Law, and I represent the appellants here, Akeem and Erica Ginsburg-Klemt, and I'd like to reserve 5 minutes of my time for rebuttal, please.
Very good.
Thank you. Good morning. Your Honor, we're appealing what we believe is an erroneous ruling by the trial court, although we understand why Judge Carroll made the ruling, that the deed at issue in this case did not act to convey the interests of two dissolved corporations to my client's predecessor in interest pursuant to a specific statute, section 689.01, which was one of the three ways a corporation can convey property. My clients, the appellants, via their predecessor in interest, which is a wholly owned corporation called Circus, negotiated for, contracted for, and paid for a parcel of submerged property in Sarasota Bay that directly abuts the seawall, which is owned, the landward property, the upland, is owned by Lawrence Point Condominium Association, and part of it is leased out to Ashford, which runs the Ritz-Carlton Hotel there. The contract, there was a contract here. It was it's in the record. It was between two dissolved corporations and my clients. There was an affidavit signed by a Mr. Robert Hunt, who is the
Mr. Coda, let's talk about the deed. I think
yes,
that's as the trial judge found, it's a gate. I think he called it a gatekeeper issue, and it kind of drives the train in this case, it seems to me. First of all, I can't even tell when I read the deed who the grantor is.
Well, Your Honor, I would
apparently it says it was prepared by your client, right, Erica Ginsburg-Klemt?
Yes, yes, it was, Your Honor. There was,
and it refers collectively to three different possible grantors. It identifies the grantors as collectively Robert Hunt, and then presumably Bennett Hunt Corporation and or Cedars Condominium Corporation, but I can't really tell.
Your Honor, I would note that you're right, Your Honor. The deed does identify Robert Hunt of both the Bennett Hunt Corp and Cedars Condominium Corp, both dissolved corporations.
But it doesn't identify his stature with either. Is he the president? Is he the vice president? Is it enough to say he's of these dissolved corporations? I don't understand what that means.
Your Honor, I think in conjunction with the statute, and this is what I think Judge Carroll was struggling with, the statute requires the signor to be an authorized agent of the company. And if you go back into the DGG case that construed this, which is really the only case that's close to being on point here, the court went into the attorney's title notes and decided or determined that one must be a president, vice president, or CEO to be able to sign.
But no one's claiming that this deed is ambiguous or you have to go outside the face of the deed. I mean, isn't the point of the DGG case that you look at the face of the deed to see if you can decipher who the grantor is? Because it's so important to give notice to the world as to the chain of title.
Yes, Your Honor, and I think that this deed does, in fact, I
mean, you can't, when you read the deed, you can't tell what Robert Hunt's relationship is with anybody.
Not on the face. Not on
to further confuse things, there's actually a passage in this deed that says the grantor covenants that this property is not the homestead of the grantor, which implies that it's an individual grantor, nor is it contiguous with or adjacent to the homestead of the grantor. It's signed by Robert Hunt in his individual capacity. The notary acknowledges him in his individual capacity, and I don't see how you can conclude that there's anything other than Mr. Robert Hunt quit claiming whatever he owns, which, as it turns out, nothing. It's just a very confusing document. I'm going to let you go ahead. I've jumped on you right out of the gate, so go ahead and walk me through your best argument.
No, Your Honor, and I appreciate you cutting to the chase, because that is, in fact, you have identified what I think Judge Carroll was struggling with in his judgment. If you read the judgment carefully, he goes through the entire analysis. He uses the word trepidation at following the DGG case as applied to our facts. Our argument, Your Honor, is that Section 689.01, read in its most plain terms, requires a deed to be signed by the authorized agent of a corporation. This deed was factually signed by the authorized agent of the corporation. There's nothing in Section 689, and I understand Your Honor's point, but there's nothing in Section 689.01 that requires that the agency of the signor be specifically listed or specified in the deed. Read in its entirety, Your Honor, and you looked at the way the grantor is identified in the deed. It is collectively, the word collectively is in there, and so our position is that the grantor is collectively, we believe, the two corporations. But although I understand Your Honor's point that that there's an argument that perhaps Robert Hunt is one of those, one or three of the grantors. But that was the intent of the deed, Your Honor, that at the signature line, that the Mr. Hunt signs of Bennett Hunt Corporation, Cedars Condominium Corporation, both now dissolved. Obviously, it's an obvious argument to state that why would the corporations be identified collectively as grantor if the intent was not to quit claim whatever interest those companies had to my client, or to our clients. And if I could go back a little bit into the facts, Your Honor, fortunately we had a really good trial judge. As I said, he issued a very reasoned final judgment, and he pointed out there's no case in Florida right now that construes the DGG opinion any differently than to say that on its face that the grantor's agency to the corporation must be identified. I'm looking at Section 689.01, and I believe the DGG case inserted something into the language of the statute that isn't in there. And we believe that it is a factual issue as to whether or not this gentleman was in fact an authorized agent of the company, and it's unequivocal that he was. He was the president of both of these dissolved corporations. And again, the reason that they were both listed is because our clients weren't sure whether or not Bennett Hunt had actually passed, whether they owned it or whether Cedars Condominium Corporation owned it because of this merger that occurred. So that's the way my client drafted the deed.
There's really no issue left, is there, that it was Cedars Condominium Corp that actually owned the property?
Yes, Your Honor, that we would concede that is true.
So I still, even if the quitclaim deed did identify Robert Hunt's relationship with these dissolved corporations, that still leaves a gap in terms of the grantor, because there's no collective grantor. There's only one owner here. It's Cedars Condominium.
Yes, and I saw that argument being made in, I believe, Mr. Costello's brief on behalf of Ashford. But I think, again, that's an argument of interpretation. We believe that the intent of the deed was to make sure that whatever interest that either of these dissolved companies had to this property passed via this quitclaim deed. And it's just a language argument, Your Honor. I understand that position, but we believe the intent of the document is clear. And I would, maybe I should transition over to that part.
Let me give you an example of what the deed should have said. This quitclaim deed made this third day of February 2011 between Cedars Condominium Corp., a dissolved Florida corporation whose address is 5100 87th Street, East Bradenton, Florida, hereinafter referred to as grantor, and SRQUS, whose address is 3364 Tanglewood Drive, Sarasota, hereinafter referred to as grantee. I mean, that something like that would remove all of these clouds.
And Your Honor, you are absolutely correct. And one of the points I was going to make as a trying to be persuasive with regard to maybe an equitable argument that appellees have devoted an extraordinary amount of time in this case to second guessing the actions of the Ginsburg Clemson. Your Honor is doing it now too, and I totally understand. Whether they should have used different language, how they could have created better language to identify the grantor or Mr. Hunt's relationship to the grantor, whether they should have recorded the affidavit that Mr. Hunt signed in which he swore to his intent to grant the dissolved corporation's interest in the QC in the quitclaim deed, and so forth. In our view, Your Honor, and with due respect, the relevant inquiry is not necessarily whether they could or should have done something different. The inquiry is whether they did enough to secure title to whatever interest these companies had in the submerged property. And we believe, and we submit, the answer to that question is yes. I did cite to a couple of cases in my brief talking about the stepping back to the intent of the deed. The parties to this deed wanted the deed to convey whatever interest these dissolved corporations had in it. That's right there in paragraph 40 of Judge Carroll's final judgment, including the dock, which is an issue that I'll get into a little bit later. As we noted in our brief, the effectiveness of the conveyance was never challenged by any of the other governmental entities or agencies that looked at this. The tax collector accepted the deed. My clients paid taxes on it. They were engaged in permitting activities with the Army Engineering Corps. Everybody thought they owned the property until, of course, it became an issue in this case. Now, assuming that Your Honor's implicit reading of the statute and what my client should have done is correct as to the effect of the deed's language here, we would respectfully submit that there should be a further analysis construing the whole of the instrument. And I cited to Hayes versus Carbonell, which is a riparian rights case, but the principle is universal, that when construing a deed should involve an analysis of the clear intention of the parties and the conditions surrounding them. The McNair versus Wade land case, Your Honor, is a timber case. That's an old case, but it's still good law. Florida Supreme Court stated that the court has the right to divine the intent of the parties, and if the clauses are repugnant to each other, they should be reconciled as to that intent. Finally, Your Honor, there's the International Kaolin case that I cited to. Clerical mistakes should be disregarded. And I'll start my video again. Clerical mistakes should be disregarded if there's substantial compliance with the statute and with the intent of the deed. And that significantly, that case construed a situation not too far afield from ours that was about signatories and witnesses. And the court noted, and I like this language, it's not the policy of our state to nullify records where substance is found. And I would respectfully suggest that, notwithstanding Your Honor's eloquent statement of what the deed should have said or might have said, there is plenty of substance here. We
lost you again, Mr. Cota.
I'm sorry, Your Honor.
We lost your picture.
And
there
I apologize.
You are. You're kind of blinking in and out.
Yeah, I'm clicking on it, Your Honor. Eventually, hopefully it will stick. I apologize for that.
All right.
So our position then, Your Honor, here is that with regard to a strict interpretation of statutory language and what 689.01 requires and doesn't require, as well as a fair-minded consideration of what the parties intended here upon reviewing the instrument as a whole, that we believe this deed does in fact pass muster, and we would ask that the trial court's decision on that issue be reversed. Your Honor, it's my understanding that I would now proceed to discuss the issues in the cross appeal. And taking some of those issues as cited in the appellee's briefs, cross appeal briefs, they're taking issue with the dismissal of the judge's declaratory judgments with prejudice. And I'm out again.
Mr. Cota, before you go into the cross appeal, normally what would happen, you proceed on your appeal, the other side responds and then presents argument as part of their time on the cross appeal. You then get to do your rebuttal and answer, and they get the final word. So if you want to address the cross appeal at this point, that's fine. I just wanted to let you know how we normally proceed.
Your Honor, I would be happy to address it after the fact, and maybe by then I can get my camera up.
All right, so you have 15 minutes total that's left. That includes your rebuttal time, so just be mindful of that.
Thank you, Your Honor.
Mr. Robinson and Mr. Costello, are you dividing your time?
We are, Your Honor. Of the 30 minutes, Lawrence Point will take 20, and Mr. Costello has agreed to take 10.
Very good. Are you going to reserve any time for either of you on doing a reply to the cross appeal response?
Yes, Your Honor. I intend to reserve 3 minutes on behalf of Lawrence Point to address rebuttal on the cross appeal issues.
And Mr. Costello, do you want to reserve any time for the rebuttal?
Your Honor, I will not be reserving time, and I may also not need my full 10 minutes, in which case, if Mr. Robinson needs to take an additional time, he may.
Well, we'll see when we get to that point where we are. And with that, Mr. Robinson, you may proceed.
Thank you. May it please the court. My name is Rob Robinson, and I have the privilege of representing the appellee cross appellant Lawrence Point Condominium Association, Inc. The trial court held that the 2011 quitclaim deed was invalid on its face to transfer the property at issue, we refer to it as the submerged land, from Cedars Condominium Association, who the court correctly notes is the undisputed owner of the property. We believe the trial court was correct. The deed fails to comply with the statutory requirements necessary for a valid corporate transfer of real estate under both 692.01 and 689.01. There was no corporate seal affixed to the deed. The purported grantor identified on the deed was not the owner of the submerged land, and the signor did not sign as the authorized agent of the owner. A recent decision from this court, which we've cited to Supplemental Authority, decided after the trial court's final judgment, we believe clarifies that even if the signor had claimed to be president of the owner, the deed would still be invalid on its face if no evidence of the claimed authority accompanied the deed. It's undisputed that here there was no board authorization or other document granting the signor the authority to act as the owner's agent under 689.01 to transfer the submerged land. Put simply, for corporations, you need one or both. You either need a seal of one of three listed categories of persons, and then also formal board authority. And without that, the deed is facially invalid, and we believe the court should affirm. There are just a few relevant facts I would like to that are germane to this specific issue. Lots of facts in the case, obviously. But Cedars is a dissolved corporation. It's the undisputed owner of the submerged land and was the subject of the 2011 quitclaim deed and this appeal. Robert Hunt was the president and sole shareholder of Cedars before dissolution. The court correctly notes that Erica Ginsburg Clement is the drafter of the 2011 quitclaim deed. There is no corporate seal on the quitclaim deed. The grantor identified on the face of the deed is Robert Hunt, not Cedars. I believe Judge Black correctly revised the deed in that manner to how it should have read. Robert Hunt signs as Robert Hunt. He does not sign as president of Cedars. There is no board resolution or other document authorizing him to sign the deed on behalf of Cedars to convey submerged land that was introduced at trial. That evidence does not exist. And frankly, the affidavit to which referred to earlier is self-serving and does not act as a corporate resolution. Robert Hunt, in the drafting of the deed, specifically rejected language that would have certified that he had legal authority to execute the deed on behalf of Cedars under the dissolved corporation statute, which is 607.1405. And lastly, Robert Hunt was personally paid $10,300. Cedars was paid nothing. With regard to the trial court's ruling, we again say it correctly determined that the deed on its face is invalid as a corporate transfer of submerged land under either of the statutes. 692.02 is inapplicable to our factual pattern, so it will not be discussed. There's no dispute that section 692.01 didn't apply here to this deed because it lacks the corporate seal as required by that statute. I think that statute has some bearing on this issue, which I'll get to in a minute, but the attempted conveyance traveled under 689.01, which is the general conveyance statute for real property in our state. It provides in pertinent part that any conveyance of real property must be signed in the presence of two subscribing witnesses by the party or the lawfully authorized agent of the party, and corporations can act only through their agents. I disagree with Mr. Coda's statement that it's not necessary to identify that on the deed that the person who signs on behalf of the corporation is the lawfully authorized agent. It may be all well and good for us in this room to know that Mr. Hunt was the president, but the fact of the matter, that's not the point of our recording statutes and the method by which people review deeds and determine through chains of title who may or who may not own property. In this case, the trial court found the deed was invalid on its face under 689.01 because Cedars had not identified in the deed as the grantor, and Robert Hunt was not identified in the deed as the authorized agent. Trial court relies somewhat reluctantly, I think, on the DGG case. And the relevant quote there, I think, is as follows. That states, similarly, if the deed is executed in compliance with 689.01, but is signed by someone other than the president, vice president, or chief executive officer, and authorizing resolution from the board of directors must be obtained. So as written, that statement describes the facts of DGG. Capone was not the president, vice president, or CEO, and there was no resolution from the board evidencing the authority of the person who did sign on behalf of DGG, and therefore it was invalid on its face under 689.01. Now that sentence might arguably imply a president, vice president, or CEO could execute a valid corporate deed under 689 without proof of lawful authority required of all agents. And we disagree with that. The trial court found that true because Mr. Hunt was the president of that corporation. But when you look at DGG and then you look at this court's decision from last year, 2011, in the George Anderson Training and Consulting versus Miller Bay Paralegal and Financing case, 313 Southern 3rd, 214, Anderson, I think, clarifies for me that the apparent authority of a corporate president or vice president to perform acts on behalf of a corporation in the ordinary course of business does not simply extend to the execution of the deed under 689.01. The operative and controlling holding in Anderson is, and I'll quote it, the deed in question was not sealed. Therefore, Ms. Ostero, the defendant, regardless of her position as president or vice president, could not sign the deed as grantor without corporate authorization. And they cite us back to 689.01. The court concludes, accordingly, the deed transferring the property from Anderson Inc. to Mr. Anderson was not valid on its face. Now, why is it important to look at 692.01 if there's no seal here? I think it's because 692 was enacted in 1971, and I believe it was an attempt by the legislature to provide a mechanism by which a corporation, through one of three listed categories of persons, could execute a deed with a seal without the necessity of a corporate resolution. And I think when you read that statute, you'll see that that's where the idea that a grantor with proper corporate authorization here is one that has a board resolution that is then recorded with the deed, which we don't have. So DGG, clarified by Anderson Training, clearly requires that even if Robert Hunt had signed the deed as president, which he did not, the deed would be invalid on its face under 689 unless there was a proper corporate authorization document obtained and recorded with the deed that did not happen in this case. So that's the long and the short of it. On this issue, and we believe that the court should affirm the final judgment as to the appeal issue. And with the court's indulgence, I'll proceed to the cross appeal issues. On cross appeal, Your Honor, the first issue I want to take up is the trial court's finding relative to counts 1 and 2, which are the forcible entry and unlawful detainer claims of Lawrence Point. The trial court adjudicated those claims against Lawrence Point. The undisputed facts really are pretty simple, that Lawrence Point not only owned the underlying land and dock, but leased that property to Ashford through its predecessor, and did retain, though, possessory rights to the dock that allowed residents of Lawrence Point to utilize that dock for up to 2 hours a day. Now, the trial court's final judgment arrives at the conclusion that Lawrence Point did not possess the dock, despite this language in the lease, which is an exhibit in the record, but then cites to no cases for the idea that you must have some form of substantial possession, or somehow distinguishing that Lawrence Point's contractual rights to possession during the day were insufficient to maintain a unlawful detainer and forcible entry claim. So we believe these undisputed facts for under lawful, and then of course coupled with the unlawful detainer law, Lawrence Point should have prevailed on those claims, and we would ask this court to remand those claims back to the trial court with specific instructions to enter a final judgment in favor of Lawrence Point on those claims on the basis of its contractual rights to possess the dock a portion of each and every day of the year.
I have one question on that issue. Your issue and the bulk of your argument on that issue is that the court erred in dismissing with prejudice counts 3 and 4. This goes to counts 1 and 2, doesn't it?
Right. My next argument is going to be on the counts 3 and 4 issue. I took up counts 1 and 2 first, just because they were counts 1 and 2 in the counterclaim, and the court, and we did cross appeal that issue. So I'm just kind of going through that.
But in your argument, if I remember correctly from your brief, your argument framed this issue as an error in dismissing it with prejudice, not as an error in coming to the conclusion warranting reversal.
No, I think the prejudice argument, Your Honor, I thought in our briefs relates only to counts 3 and 4, which were the deck actions for ownership of the dock and also riparian rights. I thought we had a separate portion of the brief that dealt with forcible entry and unlawful detainer and addressed the issue of the court's the adjudication of that issue. There was no dismissal with prejudice, but the adjudication of that issue on the facts that Lawrence Point did not possess the dock sufficient under which to maintain a forcible entry unlawful detainer claim.
And I recall that in your conclusion, but I'm not sure that it was in your argument section, but I can go back and look at that again. Okay.
I sure hope it's there. I wrote it and I sure remember writing it, but let's hope that's what got in there. But that was the one of the points for cross appeal was the court's adjudication of those claims and its conclusion on possession and why we thought that was wrong. If I move on to the court's dismissal of counts 3 and 4, those were with prejudice. There was no adjudication of those claims. The court determined that on the basis of its ruling on the deed, there was no interest to be determined, and the court would be, in fact, passing out legal advice to the parties unnecessarily. We've cited case law to this court, which we think stands for the proposition that a dismissal with prejudice really is a shorthand for an adjudication on the merits. That didn't happen in this case, so we think the court was in error first on determining that it would dismiss those counts with prejudice. If the court agrees with that. We think it's further error that the court did not take up those claims and actually consider them. And I would direct this court to the facts of this case, which are undisputed, in that apart from the deed that was obtained in 2011, the Ginsburg Clements forcibly took and retained possession of the dock from February 3rd of 2013 to June 4th of 2013. And during that time, they docked a 40-foot sailboat at the dock, preventing the use of the dock by both Lawrence Point and its lessee, Appley Ashford. The dock is further subject to a lease in favor of Ashford relative to the rights to utilize that dock throughout a day. We believe, had the trial court taken up this claim, that it should have done so, irrespective of the deed, because the two facts I've just cited to you provide additional basis by which the trial court was not just passing out legal advice. I mean, ownership of the dock is a critical issue in this case, and frankly, so is the riparian rights issue. They are linked together. So we believe the trial court not only erred in failing or in dismissing the counts 3 and 4 with prejudice, but also in not taking up those claims based upon the facts as I've outlined for the court, which are undisputed. Bennett Hunt created the Lawrence Point Condominium Association back in, we believe, in I think 1977 was when it bought the property. The dock is authorized in the first declarations of condominium created by Bennett Hunt. Those are the 79 declarations which are in evidence. The dock was meant to be a limited common element for Unit 100. Lawrence Point Condominium Association granted authorization to build the dock, I think in 1994. That's when the dock was actually constructed. The dock is again referenced in the Declaration of Condominiums as restated in 1998 version, which are also in evidence. Unit 100 is eventually sold to Ashford's predecessor, and while the unit itself was demolished, the dock was not. Simultaneously, the Unit 100 air rights and its appurtenances were sold to Lawrence Point. So at that point, Lawrence Point had already owned the underlying land as any condominium would. They then became the owner of what was the air rights for Unit 100 and in the appurtenance, which is the dock. All of this is leased to Ashford's predecessor and now Ashford, which all of that is also in evidence. So these are the undisputed facts of the dock. So the Ginsburg Clements, without a deed, have zero claim. I'm sorry.
Is there any issue that Lawrence Point owns the dock? I thought that was decided already.
No, I don't believe Judge Carroll, and I'm sorry to say I've read that judgment more times than I wanted to, but he does not make a ruling in there that we own the dock. He specifically rules that he's not going to make a decision on count 3, which was the dock ownership count, on the basis of that there was no reason to give a declaration on that issue in light of his ruling on the deed. Now, he does say that if this court disagrees with the determination on the deed, then those might be issues that would be resolved on remand. But our point is that even with the decision on the deed Judge Carroll made, we think he should have gone on to adjudicate our claims on dock ownership, given their importance not only to this case, but the relationship and the lease that we've cited to your honor.
Mr. Robinson, unless there is a further question, if you want your 3 minutes for rebuttal, you're at that point to stop now.
Very good. I will stop now. Thank you.
And also, I will tell you, I did go back to the brief, and I don't know why I didn't recall that when I asked my question, but it is, the argument is in there.
Thank you.
You're welcome. Mr. Costello.
May it please the court, Shane Costello, Ward Henderson, on behalf of Appley and Cross Appellant Ashford Sarasota LP. Ashford owns the Ritz-Carlton property in Sarasota and leases the adjacent parcel and dock from Lawrence Point. A deed is either facially compliant or facially defective. It must facially comply with either section 68901 or 69201. The trial court here found that the deed was from Mr. Hunt individually, But I think the finding of significance is not so much that Hunt individually was the grantor, but that Cedars, the corporation that owned the land, was not the grantor conveying the property. As the court has pointed out here today, Cedars is not named as the grantor or the signer of this deed. So the face of the deed does not demonstrate that Cedars was the party conveying the land in its name. And in fact, appellants do not even argue here that Cedars conveyed the land. They argue that two corporations, Bennett Hunt and Cedars, collectively conveyed the property. But it's undisputed, those two corporations did not jointly own the property. I'd also like to point out that this is not a clerical mistake. It goes to the very substance of who the owner of the property is and who the grantor is. Simply because the appellants in preparing the deed did not know who owned the property, that does not make it a clerical mistake. Additionally, the deed does not show on its face that Robert Hunt was a lawfully authorized agent of Cedars. It is merely signed by him of two different corporations, only one of which owned the property. It does not show that he was authorized by Cedars to convey the property. In fact, it does not even list him as the president of Cedars. The key here is that the face of the deed must show conveyance by the corporate grantor and that there was legal authorization to convey the property in order to be consistent with the important policy of giving notice to third parties that the property was in fact validly conveyed. So the deed must facially comply with either section 68901 or 69201, and here it did not. With respect to the DGG case, the court held the deed in that case was ineffective on its face to convey title for not being executed in compliance with those statutes. Likewise, the recent George Anderson training case from this court, in holding that the deed was not valid on its face, the court recognized that regardless of execution by the president or the vice president, corporate authorization is required under 68901 in order to have a facially valid deed. So the corporate authority must be apparent in the recorded instrument. This is what gives notice to the world of the corporation's authority to convey the land and that the conveyance is valid. Appellants have made argument here today about interpretation and intent, referencing a number of facts beyond the face of the deed, but the appellants have not contended in this appeal that the deed is ambiguous. The only question here is whether the deed is facially valid or not. And here it is not facially valid for two independent reasons. One, it's not from Cedars, the owner of the property, and two, it did not show that Robert Hunt was Cedars' lawfully authorized agent to convey the land. Moving to Ashford's cross appeal, Ashford's counterclaim seeking a declaration of riparian rights was dismissed with prejudice. We contend that dismissal should have been without prejudice because there was no adjudication on the merits. The rationale for the court's dismissal was that the counterclaim became moot upon determining the deed was invalid. Ginsburg claims in their response argue that the ruling was purportedly on its merits, and they cite the Santa Rosa County case out of the Florida Supreme Court. That case is inapposite. In that case, the trial court entered a summary judgment on the declaratory judgment claim because there was the stipulated settlement agreement resolving all disputes between the parties. We don't have any settlement agreement here resolving all disputes, and Ashford should not be at risk of any subsequent dispute over rights in this land of having to fend off a defense by the Ginsburg Clemps that Ashford cannot seek a declaration of its riparian rights based on a prior dismissal with prejudice. So accordingly, Ashford requests that the court vacate only that portion of the final judgment dismissing the counterclaim with prejudice, with instructions to dismiss without prejudice. And should the court reverse or reopen the question of submerged land ownership, Ashford's counterclaim be reinstated. And to the extent that this court decides that Lawrence Point, as the fee owner, has certain riparian rights, those riparian rights would also extend to Ashford as lessee. Section 253.141, subsection 1, Florida statutes provides that the lease of riparian lands entitles the lessee to the riparian rights running with the land. And that concludes my argument. Thank you.
Let me
Very
ask
good.
you a quick question. No one is, as we sit here today, there is no contest that that your client is not entitled to that lease, right? Nobody's,
Correct. There's been no dispute over my client's lease rights.
all right, thank you.
Very good. Thank you, Mr. Costello. Mr. Coda, you have your answer time on the cross appeal of 10 minutes. Mr. Coda, we can't see or hear you if you can hear me.
I'm sorry, Your Honor. I have attempted several times to re-engage my camera and have not been able to do so. If we could either, I don't know what you.
Go ahead and proceed with your audio.
Understand, Your Honor. So with respect to the cross appeal and the deck actions, Lawrence Point and Ashford's declaratory judgments, which they have an issue with having been dismissed with prejudice. I think what the trial court did there was ruled that Ashford's claim failed because it was contingent, and the contingency depended upon whether or not the Ginsburg Clemps owned the property. They were ruled not to own it, so there's no literal rights claim to litigate or riparian rights claim to litigate because the owners of the property by deed, cedars, would not be before the court. So as the judgment stands, Ashford doesn't have an actual present adverse and antagonistic interest upon which the court could issue a declaratory ruling. And Mr. Costello mentioned the Santa Rosa County case. We do believe it is applicable. Lawrence Point filed a similar declaratory count, two of them, and although they did not frame their declaratory claim as contingent, the trial court still could not rule on it, and I think this was a correct ruling by the judge because there was no antagonistic interest as applied to the other party, my clients, who in that event are strangers to the property. Now, we believe that, and as the trial court suggested in the judgment, if the court reverses on our direct appeal and our clients do own the property, then declaratory relief may be something to consider, but only if this court rules that there's a riparian or literal rights issue that exists here. Otherwise, there's nothing to support their claims. I didn't hear a lot of argument with respect to this Unit 100 issue, but I do want to address it because I think it's important. Lawrence Point has been making the rather novel argument that it owns the dock via airspace of a Unit 100 that no longer exists. The original dock was built as a limited common element for the owner of Unit 100 which was demolished long before 2011 when the deed at issue was formed. The Condominium Act provides that a limited common element is reserved for the use of a certain unit or units to the exclusion of all other units. Now, the 79 condo declaration gave permission for that dock to be built for Unit 100's owner, but by 2008, Unit 100 was gone. The restated condo declaration attempted to describe Unit 100 as leased airspace, but the lease applies to the entire vacant parcel. There's no unit on it. And the 2008 declaration doesn't say anything about the dock, doesn't mention it at all. What the dock is now is essentially, if anything, a common element serving all the units. But by statute, 718-103(8), common elements must be part of the condominium property. And in this property, the dock juts out into the bay, which was never conveyed to Lawrence Point. So the dock isn't on property conveyed by the developer to Lawrence Point ever. And then again, riparian rights was only briefly touched on, and I guess your honors probably know the law better than I do, since this court was the one that issued the rulings in both the 5F Dressing and the 5F Hawthorne cases. But essentially, what they ultimately held was, Hawthorne extended Dressing's holding about riparian rights, but only to the point of navigability. Keep in mind that the dividing line between Lawrence Point's platted property and our client's deed is a seawall. That seawall marks the mean high water and low water lines of Sarasota Bay. That's, there was testimony and a survey in evidence at trial on that, and yet the dock and pilings extend well beyond that. In their brief, Lawrence Point states that there's no evidence the dock extends beyond the point of navigability, but assuming that's true, the opposite also holds. We don't believe any evidence was presented that the dock only intrudes on our client's land insofar as navigability is accomplished. They are the party asserting the riparian rights, so we believe it was incumbent on them to prove it. So, from a common sense perspective, just looking at the surveys and maps and photos show that the dock juts well out from the seawall. Finally, with respect to the forcible entry and unlawful detainer counts that Lawrence Point propounded, the trial court, we believe the trial court erred. I'm sorry, Lawrence Point contends that the trial court erred by refusing standing there, but as Judge Carroll noted, actual continuous possession is an essential element of that action, and it's the Goffin versus McCall case. But Lawrence Point has leased the property to Ashford, and Ashford isn't asserting forcible entry or unlawful detainer. So Lawrence Point didn't have possession. Continuous control and possession is necessary to make that to prosecute that claim. And if I could, Your Honor, then just briefly touch on the in rebuttal on the arguments made by
Mr. Robinson, your timing is perfect because I had split your time 10 and 5 for the rebuttal. So this will be your last word on whatever you want to argue.
Thank you, Your Honor. Just very briefly, the supplemental case cited by Mr. Robinson and the DGG case contain a distinct factual difference between our case. In both of those cases, the person that signed the deed in question was unequivocally not an authorized representative. In our case, he was. And so we believe those cases are inapplicable, and this court should basically extend or issue a different opinion with regard to the applicability of Section 689.01. And thank you, Your Honors.
Very good. And thank you for your argument. So that leaves us with the rebuttal argument by Mr. Robinson, and you have 3 minutes for that.
Thank you, Your Honor. Touching briefly on the riparian rights issue, throughout this case, the Ginsburg-Clements have argued that the dock extends beyond the low water mark, relying on the dressing case. This court in the 5F LLC versus Hawthorne case, I think for the most part severs that mainmast with the notion that as a riparian owner, you can wharf out to the point of navigability, and that includes with the dock, which is exactly what we have here. And there is obviously
the reason dressing went the way it did is because they weren't asking for the right to wharf out beyond navigability. It was just an observation deck that they wanted to build. And Hawthorne clarified dressing.
That's yes, Your Honor. That's how I looked at it. And
that's how I looked at it since I wrote dressing.
You wrote dressing. But it does cite back to the Florida Supreme Court's idea that riparian rights include, among others, the general use of water adjacent to the property, to wharf out to navigability, to have access to navigable waters, and the right to accretions. So we see particularly number 2, which is the right to wharf out to navigability. I was making the point that the appellants in this case have argued low water mark is the standard. It's not. It's to the point of navigability, and there is evidence relative to navigability in that the Ginsburg-Clements sailed their sailboat up to the dock. I think, which if there's not evidence there's navigability. I don't know what is, but it certainly isn't beyond a point in time. A point in mark in the submerged lands where it could not be extended any further based upon the Hawthorne case. And with that, Your Honor, we would ask for this court to issue an opinion inconsistent with our briefs. Thank you.
Very good. Thank you both very much. Again, we've been fortunate today to have some very interesting cases, and this was another interesting case with some unusual issues. We are going to take a 10-minute recess and we'll return at 12:28 to conclude the last two cases on the docket.